Good morning, everyone, first of all, and thank you for attending today's webinar on Ukraine update with a practical perspective on handling the fallout from the conflict in Ukraine. First of all, thank you to MFB, London PNI, and 36 Stone for co-hosting and supporting today's event. And I can see, give me one moment, I can see lots of people are now joining us. Here we are. So many of you would be familiar with the YMP, but for those who aren't, let me introduce myself. I am Francesca Cappa. I'm currently chairing the YMP, the Young Maritime Professional Association. I just would like to introduce it briefly. Our association was established by Dr. Aleka in 2011 as part of the London Shipping Law Centre to promote cross-sector networking, education, professional development of young maritime professionals across the industry. It is very nice to see so today, and of course from a number of countries internationally. At this difficult time, such as what we are experiencing with the conflict in Ukraine, it is as important as ever that we keep in touch with each other, we share knowledge and experience, and maintain level across our industry. Now, of course, before we commence, I want to thank all the speakers for their time and effort in putting today's session together. And I'd like now to introduce the speakers. We will have 3 speakers today. Mark Seward, who many of you will know. Mark is a partner at MFB with over 30 years of experience in handling a wide range of matters relating to international trade and shipping disputes. Mark has extensive involvement with the Ukrainian market and is a regular visitor of the country as well. Garry Stevens will be our second speaker, and Garry is an associate director at London PNI. He's a master mariner with over 35 years of experience. Of course, many of you again will know Garry, but Garry currently is managing a team of 8 lawyers handling all types of FD&D and PNI claims from both owners and charterers worldwide. And Garry is also chairing the IG committee. And finally, we will have Tom Stewart, who is a barrister at 36 Stone. Of course, is also a member of the YMP committee. Tom specializes in international trade and shipping disputes and regularly appears in both arbitration and before the English court. Before waiting too long, I shall now hand over to Mark to start his presentation.
Francesca, thank you very much, and thank you all for coming today. I have to say I feel more than a little bit uncomfortable talking about the legal impacts of an ongoing war, particularly when it's in a country that I know so well. But there's no escaping that as Ukraine is an enormous trading nation, there is going to be global fallout and significant fallout for our industry. So what we're going to do today is talk, as Francesca says, about some more practical rather than legal impacts of what the war is doing to our industry. So we all watch the news every day and we see the conflict, but some of us may have been less involved in the shipping side of matters than others. So if I can just recap from a shipping perspective where we are. And first of all, Russia has ordered the Sea of Azov to be closed. Ukraine has suspended all commercial shipping. A Bangladeshi vessel's been hit by a missile in Olvia. An MSC crew member has been detained indefinitely for his political views. More recently, the Filipino embassy has arranged safe passage for the crews of all its vessels in Chornomorsk into Moldova, and these vessels are now laid up, and that will be something that Garry will be dealing with. The Goliath Channel is mined. The Black Sea is now in the AWC war risk area, and NATO last week issued a bulletin requesting all commercial shipping to leave the Black Sea. Now, unsurprisingly, as some of you will have noticed, there have been many articles published which are of varying use, as necessarily they're quite generic. and matters are moving on a daily basis. So the purpose of today's talk is to look at those practical issues that arise for owners, clubs, and lawyers. Now, given the sheer volume of Ukrainian trade, the impact has been significant. And we propose to look at it in the context of 4 different categories. First of all, the ships that were in port in Ukraine when war broke out on the 24th of Feb. Secondly, ships that were contracted to load in Ukraine after 24th Feb. Thirdly, those contracted to load in Russian Black Sea. And finally, those contracted to load in Russia generally. And this is probably the most difficult of the categories. And that's something that Tom will be dealing with in a bit of detail later on. Now, I'm going to look at each of these in the context of war risks. And it's important to remember something that's often overlooked, that war risks are not just an owner's problem. They have a serious financial impact on charterers. So while many charters will contain a bespoke war risk clause entitling either party to cancel, these tend to be quite restricted and will need to involve war between 2 specified countries. And usually these will be USA, USSR, Japan, and EU, and possibly China. I did see one where the recap had amended to include Ukraine, which was helpful. And I've also dealt with one which included the CIS. And this was a bit of a weird one because there is conflicting information about whether or not Ukraine is really a proper member of the CIS. But normally, the war risk clauses that we'll be looking at are ones that are intended to protect the interests of owners. And these would normally take the form of either the CONWARTIME or the voyage. Now, the general rule under these clauses is quite well established, and that there has to be a real likelihood that the vessel, her cargo, crew, or other persons on board are going to be exposed to war risks. And certainly in the context of Ukraine, I don't think anyone can doubt that there obviously are war risks. But the danger must be a tangible danger. The problem we have here is how do you really assess what that is? Now, most of the articles deal with the main authority on this, which is a case called Triton Lark. This involved transiting Gulf of Aden. And in that case, one vessel had been hit by a missile. And the owners of Triton Lark decided they did not want to go through Gulf of Aden. And they relied on the CONWARTIME 1993. Now, Mr. Justice Tier didn't think that one vessel out of 300 was enough. And this is what makes it so difficult in the context of this war, because everything is changing day to day. Now, I'll give you 2 practical examples of how these sort of clauses can work. I dealt with a case just before the war in Syria a number of years ago, and the owners of the vessel received an email from the Syrian Liberation Army warning them not to go to Latakia. A little bit of Googling revealed that the Syrian Liberation Army was a dental student in Damascus. So one might think that's not a credible threat. But when it came to arbitration, the arbitrators had a lot of difficulty distinguishing between the risk at the time they were taking their decision and the risk at the time the owners took their decision. And they became quite confused. And the second example I'll give you relates to calling at Lagos. Now, Lagos has been a war risk area for absolutely years, and tankers are regularly boarded, looted, and crews attacked. But only one bulk carrier ever had been attacked in Lagos. And the owner in the case I dealt with a number of years ago requested military assistance and an attending frigate throughout all of the ops, which you might think is unreasonable, but it turned out that the previous bulker was actually theirs. So the first of those is a good example of how you need to assess the time at which the decision is taken. And the second is a good example of how impossible it is for you or I, as an objective bystander, to really understand what an owner is thinking when he's making his decision. And the final point before turning to some examples is it's worth noting that the CONWARTIME 2013, which is the one we see in the charters currently, are ones that has been amended, but as yet is untested. Now, BIMCO specifically state that it's been amended to deal with the uncertainties in the Triton Lark, and that it talks about whether or not an area is dangerous or may become dangerous. I'm not sure it's necessarily going to solve the problem, but it's going to be something which will be part of disputes in the future, I'm quite sure. And also it's been amended to make no requirement for the situation to have changed from the date of contracting. And the VOIWARF 2013 has been tracked to follow the same wording as the CONWARTIME. So in short, an arbitrator needs to take into account all of the factors that are available. And it's not good enough to look back and look at what factors were there. They need to be in the individual's mind when they make the decision. So if we turn to the specific examples, I'm sorry I'm rushing through this, we've only got a short period of time, but on the 15th of February was the date that the JWC allocated war risk status to Ukrainian waters in the Black Sea. And it was on that day that we started to receive questions from people about the risks and rights and wrongs of calling Ukraine. And at that stage, there was no suggestion there was going to be a war. Indeed, quite the opposite. No AP had been quoted by the market, and all trade continued normally. So I do not think that the mere imposition at that point would have been enough to justify not calling. But if we look at the actual examples of the vessels that are in difficulty now, the first of those is the vessels that are in Ukrainian ports now. At 1100 hours on 27th of February, the ports were closed to commercial shipping by the Ukrainian government. I'm not entirely sure why that happened, but I'm sure there's quite extensive legal advice flying around about insurance and crewing matters. But there are part laden vessels in Nikolaev and part discharge vessels in Chornomorsk. And while these are limited in numbers, they are causing big problems for the owners and charterers of those vessels. An owner is obviously not going to want to terminate the charter. So the question really becomes, what can a charterer do about that? The answer is not a great deal. If the vessel's completed discharge, it can be redelivered at berth under the principles of Greek fighter. But if the vessel is laden, I've not been able to find any pro forma charter which would assist the charterer in placing a vessel off hire. It may be that there are some, if the vessel is decrewed, for example, there will be a deficiency of men sufficient to put her off hire, or there may be a bespoke rider entitling off hire to be called in the event of a detention. The reality is, a charterer has very limited options, and I'm aware of a number of ships sitting in Nikolaev where time continues to run against the charterers. And the same, of course, would be the case on a voyage charter basis. So the war has caused a very real financial impact on a charterer as well as an owner. Now, I think the largest category of vessels will be those that were already fixed before the war. And this raises some interesting questions. And materially, the considerations you'd think under a voyage charter and a time charter would be the same. But that, in fact, is not really the case. When it's coming to load, an owner, of course, under the CONWARTIME can call for a different port of loading. But under the VOIWARF, if you have a disponent owner, that is not an option that is open. Before cancelling, it's necessary to give a 48-hour notice, requiring nomination of a safe port within the range. But in my experience, Ukraine is a very peculiar and particular trade. I think I've never seen a range in a voyage charter for calling Ukraine. It's almost invariably for a specific port. So there's not a lot a disponent owner can do to call for his charterer to perform. And the reality is those charters will need to be cancelled, and disponent owners will be left with vessels with no cargoes. And that has, in my experience, already happened on quite a number of occasions. Obviously, moving forward, there's no one going to be calling at Ukrainian ports for the sort of foreseeable future. And we will talk about our views on where things are likely to go later on. But in the context of this particular part of the talk, the last category of ports are going to be Russian Black Sea ports. And these have caused a lot of controversy. Because if you cast your mind back to the objective test, you need to look at all of the evidence that's available now in deciding whether or not you want to call it a Russian Black Sea port. And I looked at AIS this morning, and the ports of Taman and Novo are still very, very busy. And if an owner does not want to call, what is he to do about this? There is limited information available. P&I Club will go to a P&I correspondent, obviously, and those Russian P&I correspondents will always advise that everything is fine and safe. One would not expect them to say anything else, obviously. The ports are apparently operating normally from an outward perspective, and one P&I Club circular did suggest they were unsafe. And this caused a lot of furore, and that circular was withdrawn. So at the moment, the only evidence that an owner can see as to the operation of those ports is that they are normal. So I have a little difficulty in seeing how an owner could justify not calling. But I would put one caveat on that, and that concerns vessels with Ukrainian crew. It seems to me in that context there's an entirely different set of facts that you need to consider in making that decision. For example, GARD, I know, has advised that it considers all Russian ports to be unsafe for Ukrainian crews. The Ukrainian Seafarers Union has issued a circular requesting that their crew members refuse to go on the basis of unsafety. JWC has now included Russian Black Sea in its war risk zones, even though there is no war there. And last and perhaps most importantly, it does rather appear now that Mr. Putin has declared war on the Ukrainian people. And I would think taking a vessel with a Ukrainian crew to a Russian port generally is something that an owner would be able to refuse to do, certainly in the context of the CONWARTIME. Now, Tom's going to look at different issues that arise in relation to Ukrainian crews in his talk. But for the purpose of this, on the CONWARTIME at least, I think an owner is justified in refusing. So for me, that's probably all I've got to say for now. And obviously, I suspect there are more questions raised than answers. But these are things we can look at the end in a general discussion, because there are quite a number of things that we do need to talk about. Okay, thank you. And Garry, over to you, I think.
Thanks, Mark. Can anybody hear me? Just checking.
Yes, we can.
Great. Thanks a lot. Right. Nice to be here and see so many people attending. A bit more than we first expected when it was just going to be the YMP, but welcome to everyone. And I do see actually that we have some underwriters attending. I think you can see from my bio that I'm actually on the claim side, Master Mariner, not a lawyer. And Francesca says I'm chair of the IG committee, actually chair of the IG correspondence committee. So the issues in Ukraine and Russia affecting our correspondence are very dear to my heart, as well as the owners and charters that we have from that part of the world. I've been asked today to talk about war risk cover. And of course, I'm from a P&I club. I'm not from a war risk underwriter. But actually, the London Club does offer war risk cover, which I'll talk a bit about later on. Now, owners, when it came to, as Mark was saying, when Ukraine was declared an AP area, owners and charters start asking themselves, oh, what have I bought in respect of war risk. As we know, owners buy hull and machinery cover, war risk hull and machinery, also war risk P&I, and they buy P&I cover, hopefully from one of the international group clubs. But when it comes to the crunch, and you find yourselves in this situation that we have now in Ukraine, people turn to their underwriters, turn to their brokers, and ask, what actually have I got? How does it all work? And we in the P&I clubs immediately, just like we had to do 2 years ago with COVID, which was a new situation for us, we have to look at our rule books and decide what we cover, what, more importantly, what we don't cover. And if you're buying just your hull and machinery and war P&I from the London market, for example, your hull cover is usually up to the value of the vessel. The war P&I itself is also up to the value of the vessel. But in a situation where you have a serious incident with a missile attack or such like in the Ukraine, then your cover up to the hull value is clearly not going to be enough. So it's always recommended that owners take out additional cover way above the hull value, or certainly separate cover, so that at least you've got the hull value for the war hull and machinery cover and the hull value for the P&I war. But the international group of clubs offer excess war P&I cover over the value of the insured value of the vessel, right up to 500 million. That's something the clubs have, as a group, have got involved in together to offer that to ship owners. Alternatively, the P&I clubs themselves offer war risk cover, and the P&I aspect of that is not limited to the value of the vessel. It can be right up to $500 million. And one of the issues that owners have, if you have separate war risk P&I on the market from the P&I club, is making sure there are no gaps in your cover. That's very important. And as probably most of you know, in the P&I club, we have exclusions for any incidents caused by war. And if you look at the club rules, there are exclusions for any incidents from war, capture, or even hitting a mine anywhere in the world, not necessarily in a war area. Now, this today is very important. I think most of you will have seen the circulars coming from correspondents, particularly in Turkey, where mines have now been spotted at the entrance to the Bosphorus from the Black Sea, and ship owners are being asked to move away from the anchorage area. But if a ship does strike a mine in that part of the world, of course, P&I cover excludes any deaths or injuries occurring to the people on board from such an incident. Now, going back to Ukraine and the situation where ships are stuck there, crews are still on board. Although it's a war risk area and it's been declared a war risk area, normal P&I incidents will still be covered by the P&I clubs. The usual trips and falls or anything happening to a seafarer on board, which is a normal P&I incident, it will still be covered by the P&I clubs. And as Mark was saying, that whole part of the world now is declared an additional premium area for war risk, and the clubs are entitled, and the war risk insurers can give 7 days notice of cancellation. That can be reinstated upon payment of the appropriate additional premium being charged for the area. Now, the other P&I problems I think Mark was talking about was when the ship's in port now and the Ukrainian crews or any foreign crews on board, who wish to get home. As Mark said, the Filipino embassy has facilitated Philippine crews leaving. But then that gives a problem as far as the clubs are concerned, because in the London Club rules, Rule 8.7 talks about safe manning, and every ship has to be manned in accordance with flag state requirements. Now, if all your crew were Filipino and they have left, you have a problem there that the vessel is not manned properly. Now, a way around that, of course, is to lay up the vessel, either in a hot layup or a cold layup. That needs to be done properly. At the IMO, the Ukrainians have given suggestions on how to do that. Make sure the vessel is as safe as possible for normal risks. Of course, it's not going to assist if a missile strikes a vessel when she's alongside. Also, the clubs and others are now denying cover for Russian vessels, and also Russian class is now not being covered by clubs. We have some members in the London Club that have Russian class, and we've reached out to these owners, and of course they're all now going to have a certain period of time when they can switch class to another society. As far as our charters are concerned, they're now not in a position that they're able to charter in Russian vessels. Now, I know we're not talking about sanctions today, but of course that is a massive issue and a massive problem for all our members. Also, as far as P&I is concerned, you have each ship has a blue card on board as far as CLC for pollution risks and so on. And that is a guarantee that claims will be paid. So these certificates could be called upon if there's an incident and a pollution. The clubs may have to step up to the plate and settle claims, but of course they would have an indemnity against the owner and his war risk P&I insurer for recovery. Moving on to what is clearly, to me, the most important, being a seafarer myself, is how it works for the seafarers on board. And we've had lots of requests from owners as how do we deal with our Ukrainian seafarers who are at sea and are desperate to get home to their loved ones, and they're looking to get flights back to a safe country. I think normally it's Warsaw and Poland that seafarers wish to go to. But P&I, normal P&I covers a seafarer at the end of his contract when he's flying home till he actually gets home. But quite clearly, that's not going to be possible for him going into a war-torn country to get back to his home if in the fortunate event that his home is still standing. So the international group got together and came up with a template for ship owners to use to allow their Ukrainian seafarers to get back, to sign a waiver that they accept that the termination of their contract will be when they arrive at that safe airport, which would probably be Warsaw. So it's important, though, that the ship owner also checks the terms of the actual contract itself and make sure the template works with the crew's contract so that he can leave the vessel. Now, these costs returning, of course, are operational. It's just changing the time when he's actually going home. It could also be that you have a seafarer who doesn't want to go back to Ukraine, and the Ukrainian Union has said that that's not a problem, and contracts can be extended over the usual period, the maximum period under the MLC could be exceeded, which gives seafarers rights against the ship owners, but that could actually be, his contract could be modified to allow him to stay on board for a longer period of time. Now, another problem that is happening with seafarers is paying them, getting money back to their families, wherever the families are. The banks that they've been using to have their allotments sent home every month may now not be possible, and this is causing huge problems. I'm sure the clubs will assist owners in looking at different ways to make sure that the families, wherever they may be, somehow get the salaries of the seafarers. As Mark pointed out, that seafarers, Ukrainian seafarers, are having problems when going into Russian ports. As he said, on an MSC vessel, a seafarer, they're looking at mobile phones of the seafarers to see what they're actually saying about the conflict or the special operation in Ukraine, as that is being mentioned by the Russian media. As chair of the correspondent committee, I feel very strongly for our correspondents, particularly those in Ukraine who are still sending us so much information, as much as they can, about what's going on. We're worried about how we can pay them. We're also worried about our Russian correspondents. And although there are no sanctions against paying the Russian correspondent, as in all these cases, the banks step in and can cause issues, because even if it's a legitimate payment to a legitimate correspondent, the banks just won't send money to a Russian bank. We've had this problem before in many countries, in Libya in the past and in Iran, and it's a difficult situation for correspondents who do their utmost to help our members around the world. I think I've covered, as far as the P&I is concerned. On the claim side, fortunately for us as a club, even in our war risk cover, our members of the War Risk Committee, we do not have any vessels currently stuck in Ukraine. But once again, we will look at the rules. I've actually dealt with a couple of war risk covers for piracy in the past, but it's an area of cover we always hope owners will never have to turn to. I think I'll leave it there and pass over now to Tom.
Thanks very much. Thanks very much, Gary, and thank you very much, Mark, and thanks to the YMP and LSLC for inviting me today. It's not going to be possible for me to get through all of the relevant legal principles in the time available, but what I hope to do is to sketch out some of the key issues that might arise in terms of owners and charterers who find themselves caught up in the current conflict, and offer some tentative suggestions about how those principles may apply to particular circumstances. I'm going to focus on the charter party position, but there are obviously similar issues that arise with all aspects of international trade, commodities. It's not the function of this talk, as Mark says, to address sanctions and so forth, but I will touch on them insofar as they're relevant to the principles that I'm going to talk about. At present, the advice being sought is urgent guidance on how to proceed, and two of the key issues are firstly whether the charter can go ahead at all, and secondly what happens with charterers already partway through. But there are undoubtedly going to be a huge number of cases coming to arbitration in the courts in due course arising out of these events. Each charter will of course have its own terms, and different considerations will arise, but I want to discuss three overarching concepts, namely unsafety, frustration, and force majeure. Now, the principles will be well known, I've no doubt, but they're worth repeating briefly. Firstly, unsafety. The question in all cases is whether the particular ship can reach a port, use it, and return from it without, in the absence of some abnormal occurrence, being exposed to danger which cannot be avoided by good navigation and seamanship. That's the test originally set out in the Eastern City, approved in the Ocean Victory. An abnormal occurrence is a possible defence to a charterer to an allegation of unsafety, but the occurrence must be well removed from the normal, out of the ordinary course, and unexpected. The port must be prospectively unsafe. In the Evia number 2, following the outbreak of war between Iran and Iraq, the vessel became stuck in the Shat al-Arab waterway, and there's a number of cases that I'm going to talk about in due course arising out of that event. It was held that the charterer was not in breach because the port was prospectively safe when the vessel had been ordered there, but had become unsafe by reason of supervening hostilities. As Lord Roskill said, the charterer's contractual promise must, I think, relate to the characteristics of the port or place in question, and in my view, means that when the order is given, that port or place is prospectively safe for the ship to get to, stay at, so far as necessary, and in due course leave. But if those characteristics are such as to make that port or place prospectively safe in this way, I cannot think that if in spite of them some unexpected and abnormal event thereafter suddenly occurs, which creates conditions of unsafety, and as a result the ship is delayed, damaged or destroyed, that contractual promise extends to making the charterer liable for any resulting loss or damage, physical or financial. Turning then to force majeure. Force majeure necessarily comes before the concept of frustration, because the existence and scope of a force majeure clause is very likely to affect any argument on frustration. If the contract contemplates the supervening event or the type of event, it cannot be said that the supervening event renders performance of the contract radically different from that contemplated at the time of contracting. Force majeure is, of course, a creature of contract, and its functioning depends on what has been agreed by the parties. Parties must generally show that a specified event has occurred, that the event has prevented or hindered performance directly or indirectly, that the delay or hindrance was due to circumstances beyond that party's control, and that there were no reasonable steps that could have been taken to mitigate the event or its consequences. Listed causes in force majeure clauses very often cover war or warlike activities, but will also often include a catch-all for any other cause whatsoever, or merely any other cause. And practitioners should always be careful of the a justem generis principle in checking the scope of those clauses. Note also the use of words such as hindered or prevented. The word hindered has traditionally been construed more generously than prevented. See Tenants, Lancashire Limited against C.S. Wilson and Co. 1917 AC 495. Recent case law on the COVID-19 pandemic is also instructive. See, for example, Fibula Air Travel SRL against Just US Air SRL. That case concerned a wet lease for the charter of an aircraft for commercial flights between Romania and Turkey. The claimant said there was a force majeure event the day before the first instalment was due, but Jacobs J, on an application for an injunction, doubted the claimant's case. Commercial flights were not suspended between the two countries until some weeks later. And even though by then the pandemic was widespread, the existence of the pandemic was not enough. It was necessary to identify the consequences of the pandemic upon performance of the contract. A similar point can be made about hostilities in Ukraine at the moment. The mere declaration of war and the fact of war is not necessarily enough. One has to look at the relevant acts of war to see how it affects performance of the contract. And while it's not the function of this talk to discuss sanctions, I can't overlook the recent judgment of Jacobs J and RTI against MUR. There, the contract provided for payment in US dollars. The charterers, RTI, were sanctioned. Owners pointed out that payments in US dollars would constitute a breach of those sanctions, which they said was therefore a force majeure event. Charterers said they could pay in euros instead. The tribunal agreed, saying it was a completely realistic alternative. The court disagreed, holding that the parties' control obligations were not simply one factor to be weighed in balance in deciding the overall question of reasonableness, but were paramount and determinative. A party was not required by the exercise of reasonable endeavours to accept non-contractual performance in order to circumvent the effect of a force majeure or similar clause. Turning then to the third concept, which is that of frustration, the general test is that a contract will only be frustrated where either performance is impossible or the circumstances in which performance is called for would render it a thing radically different from that which was undertaken by the contract. That's per Lord Radcliffe in Davis Contractors Limited against Fairham UDC. Excessive delay is often a reason relied on for frustration. Each case, however, turns on its facts. In the Sea Angel, a vessel was chartered for up to 20 days, but in the event was detained by authorities for an additional 110 days. That was held by the Court of Appeal insufficient to frustrate the charter. However, Lord Justice Ricks said that what is required in cases of frustration is a multi-factored approach, delay being just one factor out of many. The COVID-19 pandemic once again provides pertinent case law. In Bank of New York Mellon against Cine UK, the closure of a cinema for 18 months was insufficient to frustrate an 18-year lease. War raises different considerations. As Lord Justice Ricks said in The Sea Angel, one cannot negotiate or litigate one's way out of such consequences of war. He was referring there to the line of case law following the outbreak of the Iran-Iraq War and the closure of the Shat al-Arab waterway. And those cases include the Agathon. Frustration was arguable where the crew had abandoned the vessel and returned some months later. The Wenjiang No. 2, where the court upheld the decision of an arbitrator that a charter party was frustrated after 2 months of the vessel being trapped in the Shat al-Arab waterway. The Chrysalis, the charter was frustrated on the date on which it became generally accepted in shipping circles that passage out of the Shat al-Arab waterway was likely to be impossible for some considerable while to come. However, note it was not the declaration of war which frustrated the charter, but the acts themselves. In the words of Lord Justice Ricks in The Sea Angel, if in such circumstances the Charter has not made express provision for what has occurred, as may yet happen, e.g. in the case of requisition by reference to a war clause, the possibility of frustration, subject to any default by either party, can never be far away. These days, of course, there often are war clauses dealing with these situations, such as those touched on by Mark in his talk. Sanctions are also important. Contract may be frustrated by supervening illegality, for example. I'm not going to get into the nuances of the case law. The essential principle is that a contract may be discharged if its performance becomes illegal. Turning then to the application of those concepts in the present climate, there are obviously a huge number of possible situations that ship owners or charterers may find themselves in. Starting with some straightforward situations, if a ship on a long-term period charter is ordered to go to a Ukrainian port, they can very likely refuse to do so on the ground that it is unsafe. Generally, a period charter will allow trading in reasonably broad geographical areas, so there's very unlikely to be any question of frustration. For a voyage charter, the situation may be more complicated. However, an owner may be entitled to say that there's a force majeure event preventing or hindering performance. It will, of course, be important to ensure compliance with any notice provisions in the force majeure clause and any other requirements that may be preconditions to reliance on the force majeure provisions, such as taking steps to find alternative means of performance. Timing is also going to be important, because there will be a question as to whether the hostilities were known about or likely or in prospect at the time of contracting. Some voyage charter forms, such as BP Voy form, may include a provision allowing the vessel to proceed so near thereunto as she may safely reach. And in those circumstances, the owner may be entitled to a quantum meruit for the additional time taken to reach alternative ports, see the Baptist. What then of the position of a vessel already in a Ukrainian port and unable to move? The owner may be entitled to rely on force majeure, but again, note the possible requirements in the clause about giving notice and taking steps to find alternative means of performance, be it that those are unlikely to prevent reliance on the force majeure clause. In terms of frustration, the Iraq-Iran war line of case law may be pertinent, but as with all of these cases, it will depend on the terms of the charter and if provision for the circumstances has already been made. In the meantime, hire may well continue to accrue, so the owner may not be too concerned, but no one is a winner. The owner will be stuck with a vessel and crew in a war zone. Hire is likely to be of very little consolation. Finally, then, what about charters to Russian ports? This is perhaps the most difficult question because the practical reality of what an owner or charterer may wish to do is not necessarily supported by what the case law or concepts, legal concepts allow them to do. Owners may be concerned if they have Ukrainian crews. They may also be worried about the possibility of future sanctions. An owner may not want to go to Russia if it risks blotting their copybook and later preventing trade to other countries. But what basis could an owner have for refusing? It's hard to see how force majeure or frustration could come into play in those circumstances, given that generally at the moment Russian ports are open for business and safe. There are cases where frustration has been found for leases of residential premises which the tenant cannot put to the use intended because of wartime restrictions on their freedom of movement or on the group of persons to which they belong. Typical case being that of a lease of premises for residential purposes in which the tenant cannot lawfully reside because of their enemy alien status in wartime. But it's hard to see how an owner could rely on the potential enemy status of a Ukrainian crew in Russia as frustrating the charter party. Costs may be higher, but additional expense is rarely, if ever, a frustrating event. Supervening illegality may come into play if there are sanctions issues, but may not if the sanctions are not yet in force. Unsafety is probably the argument that is most likely to succeed. While the focus is usually on a risk to the ship, it's suggested that risks to her crew can render a port unsafe, even if there is no risk of damage to the ship itself. In other words, a port would not be safe if there is a threat merely to the crew, albeit no threat to the ship. But it may be that owners will simply have to take their chances and see how it pans out in litigation in due course. I've now run out of time, I believe, but we've had various questions coming in. So if the panel's ready, and unless Francesca wanted to say anything else.
No, thank you.
Open up the floor.
Absolutely. Thank you very much, Tom. I shall now leave it to you to deal with the questions. And of course, if anyone has any questions, they can write them on the chat, as people have already done so. Can you see the questions? Yeah.
Yes, I can, Francesca. Yeah. So the first question is, where a cargo destined for Ukraine cannot be delivered or discharged in Ukraine, what can or should be done with the bills of lading? I don't know if Mark or Garry wants to have a go at that first.
I'll have a shot at that to start with. I mean, it is actually a fairly topical one, because I actually got an ongoing case dealing with precisely this. And this was, the cargo was destined for discharge in Chornomorsk about 3 weeks ago, and there was an argument about going to an alternate discharge port, which was ultimately agreed. But the bills of lading are in Kiev, and as a consequence, there's no one there to surrender them, and no one can get hold of them. And what's a little bit weird about the voyage clause is it makes no provision whatsoever for what is to happen with the bills of lading. And I think that principally, because it's drafted not anticipating there to be the possibility of a disponent owner. So that with the voyage clause, if there was no disponent owner, the bill of lading would only be a receipt and therefore a less important document. But at the moment, all the voyage does is mean the discharge at the other port is not a contractual deviation. But it does not mean, for example, if you want to deliver against an LOI, the person you're delivering to is likely to be a different party. So the reality is you have to reach an agreement between the owner, the receiver, the new receiver, and the charterer as to what is to become of those bills. There's going to be a certain amount of letters of indemnity, but the reality is it's going to rely on the cooperation of the parties. And in all likelihood, time, whether lay time or detention or otherwise, will run against a charterer or cargo interest under the BLs until agreement is reached. But it's a bit unsatisfactory. The clause does not deal with how bills of lading are to be dealt with. So there's no real answer. There's a statement, but no answer to that question, I'm afraid. I'm sorry.
Garry, I don't know if you wanted to say anything. I don't have anything to add to what Mark says. As far as I'm aware, there is no answer. As Mark says, it's not a straightforward question, but nothing is in the current situation.
I think, and of course you get the club claims handler just points to the club rules about delivery of cargo to a place other than that named in the bill of lading. So yes, a commercial resolution would have to be found.
A question for Garry has just come in. Most of P&I clubs are considering whether or not to confirm P&I cover to entered vessels now targeted by OFAC, UK, EU and other sanction regimes. In 2010, the UK Commercial Court rendered a judgment in the case SMUAL against Iran shipping lines, the steamship case. A contract of mutual indemnity insurance given by a P&I club to an Iranian shipping company had not been frustrated by the imposition of the sanctions order made by HM Treasury. The vessel Zurich, which suffered a casualty off southeast of China, no frustration occurred, is a lesson to be learned. And what do you think IG approach will be? That's from Marco Mastrapasqua.
Right, this is, but you're saying it's not a sanctions issue, but it certainly is a sanction issue. And I think we would be unable to give cover to any, we have sanctions clauses allowing us not to be giving cover for anyone who's sanctioned under the American or the EU sanctions. So I think cover would have to be refused in such a situation.
Thanks very much. And there's a question here from Tatiana Jacob. If a charter is suspected to be connected with a sanctioned entity, it could impact its ability to lawfully perform its payment obligations. Could a charter party be frustrated in this case because of the effect of supervening circumstances on the payment obligation? I think the answer to that is to look at the judgment of Jacobs J.N. RTI against MUR, a force majeure case. But the key principle set out there, which is the one that I touched on in my talk, is that a party is not required to accept non-contractual performance in order to circumvent the effect of a force majeure or similar clause. And similar principles would probably apply to the question of whether the charter party has been frustrated or not. Obviously, whether the sanctions were sufficient to justify frustration of the charter party is a more difficult question. But there could be circumstances where that could be the case. Another question here: should vessel owners be required to carry out crew changes of Ukrainian crew in response to concerns about voyage orders to Russia? Don't know who wants to have a go about that.
I'll have a start on it, Tom, and you can finish it if you want. I don't know if it's the real answer, but it's a difficult question. Under the provisions of CONWARTIME, for example, there is a liberty to change the crew. So it could be suggested, and has been suggested, that an owner in those circumstances should be required to change their crew to enable it to call at Russian ports. I view the terms of the CONWARTIME to be very much a liberty on the owner. And the situation regarding this crew change, the reality is when you're making that decision, you can't just find a Filipino crew lying around in Murmansk or somewhere and swap crews, or in Seward. The reality is you have to change somewhere else, and you've got a system in place on your vessel which, let's say, for whether it's Ukrainian, Chinese or whatever, where the entire vessel SMS will be set up in a particular language. And I just don't think it's practical, even were it to be lawful to require an owner to change a crew. Just to change the nationality of the running of a vessel, I think is something that's just not practical or sensible. But I mean, the question that you raised, Tom, I mean, it does have a place in the context of the long-term charter. I mean, if you've got a 5-year charter and a vessel's going to be calling to Russia, as vessels do on a regular basis, that might put it into a different context. So it might come down to timing. But what do you think about how that fits in with, well, there's never going to be a frustration, but what does a charterer do in those circumstances? Does he order a vessel to go to Russia, have the owner refuse, then perform some other business and sue the owner, and then order the vessel to go to Russia again and continue making windfall profit when never actually intending to go to Russia? I mean, there's no obvious answer to that. I think for me, I think it's a liberty only, and no more than that.
Yeah, and it must play into the question of what's possible to do to circumvent a frustrating or force majeure event. It's all very well saying that it's in theory possible, but the practice of actually carrying that out may be a different thing altogether. Expense is obviously rarely a consideration, and it may be said that the owner should simply swallow all the additional expenses of having to make those changes, but there must reach a point when it's simply not practicable. But it would be very difficult to say in the abstract.
No, I agree.
There are two further questions that have come in. Under the BIMCO Voy War Clause 2013, would time count if the owner elects to not exercise the option to cancel the charter party? I don't know if anyone wants to have a stab at that. My instinctive reaction would be to say that time should still continue to count if the owner elects not to exercise the option to cancel TP, but I don't have the Voy War Clause 2013 in front of me.
Yeah, I mean, it's a difficult one because in the context of a voyage charter, an owner needs to get somewhere to enable himself to start time counting. And if he's refusing to go somewhere, I don't know whether he will be able to start time, but I would agree with you that if he was in the right place, then time would run. And if it's a question of refusing to leave a load port or enter a discharge port, then time should run, I would imagine. Yeah, that certainly would be my view.
Francesca, I don't know how we're doing for time. I can see that there are still questions coming in, but there's obviously limits to how much we can, how many we can deal with in the time available. I know people have got to get away.
Sure. Tom, I think we have another 10-15 minutes, so I think we should, we can at least try to answer some of them, and then, if there is any other that remains, then we can always address it separately, perhaps, if that's okay for everyone.
Yeah, I should say, if anybody has any further questions, I'm sure I speak for the whole panel when I say that they're very welcome to email us separately. I think our details will be on the handout that Gerard sent round.
Yes, they can email the London Shipping Law Centre, and then we can then pass them to you if that makes it easier. Yeah.
Maybe that'd be the best way to do it. Yes. So another question here is: a vessel is stuck laden in Ukraine, and the cargo condition deteriorates. Does that have an effect on charter party frustration? My immediate reaction to say that probably wouldn't frustrate the charter party. There may be a claim for damages. Whether there would be a defence to a claim for damages may be a separate question. I suppose there may come a point when one might say that the charter party has been frustrated because it can no longer be performed if the cargo can't be delivered in any meaningful way. If anyone wants to venture some thoughts on that question.
By anyone, Tom, I know you mean me. So, but I do agree with you.
Mark.
Frustration is such an interesting area, and I can see an argument to the effect that the commercial purpose of that contract is gone once a part-laden vessel has a severely damaged cargo on board. That would make a lot of sense, as you say.
I think, given the time, Mark, it's time for you to do a final thanks.
Okay, I will do that.
If you can do that in 5 minutes or so, and then we can wrap up. I'm being told that we're coming to the end of the allotted time.
Okay, well, thank you very much indeed, Tom, for that, and Garry and Francesca. It's been, I hope, as interesting as a lecture can ever be at this time of morning or evening, wherever you happen to be. It's been interesting for me looking into these issues because I've been quite close to them over the last few weeks. And it's quite incredible, as even can be seen from the questions that have come in, quite how many issues do arise in the context of what's happening. And it can only be hoped, as has been the case in certainly one or two of the cases that I've dealt with, that people accept that what's happened with this war is so grave, generally for everybody, that a lot of owners and charterers will just get over it at the end of the day and not litigate these issues. And certainly we've had a couple of deals done that way where people have just said, okay, fine. And I hope that's what we take from the discussion that we've had today, that this could be a problem which gives rise to an enormous amount of litigation, or, as the case may be, not. And I think this has been a useful forum, and thank you, Francesca and Gerald, for hosting this, just to put some ideas out there and help everyone realise how difficult a lot of these questions are and how difficult law is to apply in practice. General guidance doesn't really help. And as Tom says, everything is fact specific and everything is going to be different. And I just hope that we've given a bit of insight into these problems as and when they might arise. And again, say thank you all again for coming along and sparing some time to listen to us talking relatively incoherently about the situation in Ukraine. And thank you again, Garry, for the insight onto the PNI side of it, which was interesting. It's certainly something I'd appreciated.
Thank you very much, Mark. And thank you everyone again for coming. Goodbye.